A lot of times contractors feel like maybe less paper is better, and we'll talk to you about that and why that isn't necessarily the case.
But if there isn't a written contract, then that just opens it wide open to differences of opinion in terms of what was agreed to, what the scope of the work is, who's responsible for what.
Hi everyone. Today we're going to be talking about construction contracts, why they're important, what you want to have in them, how they can protect you, and how they can be good for you. A lot of times contractors feel like maybe less paper is better, and we'll talk to you about that and why that isn't necessarily the case. In fact, with me is my law partner, Hugh Higgins. And Hugh, this past year, we had a case that you were primarily involved in where the agreements between the parties to a construction contract was not in writing. It was an oral agreement. Let's talk a little bit about the challenges that poses when you run into a problem down the road on a construction project.
Absolutely. Well, regardless of whether we have a written contract in place or not, there often tends to be a he said, she said scenario developing in cases. But if there isn't a written contract, then that just opens it wide open to differences of opinion in terms of what was agreed to, what the scope of the work is, who's responsible for what, and then you essentially end up tracking down text messages, emails, oral statements, and it becomes a labor-intensive process to figure out what the agreed-upon terms are. And then it also becomes just factually very difficult to determine cleanly who's right and what controls.
Yeah, and so at that point, you're basically asking the court to decide what were the terms of the agreement between the parties, because then you've just got to get the opinions of the owner and the contractor, or the contractor and the subcontractor. Is that right?
Right, and practically speaking, you're going to be forced to a jury trial, because if there's a dispute of fact, one party says we were obligated to do something and the other party disputes that, a judge can't decide that kind of issue. So you're going to be forced into a jury trial. It's an expensive process, and there's not going to be any way without a settlement to resolve it on the early side.
Right. And jury trials will be something we get into later in talking about whether or not you want to have something that addresses a jury trial in your contract. And we'll talk about that later. I want to talk a little bit about having the written contract versus not. In Florida, it's not a law that contracts be in writing, except as to certain types of contracts, but construction contracts are not one of those. Construction contracts can be oral or they can be written, but certainly you can do a much better job of protecting yourself with a written contract. And that sort of leads us into the different types of contracts that we run across in construction projects, most of which you would be familiar with. One term that I've heard in the past used is sort of a confusing term, but it is project delivery methods. And basically all that means is the contract a cost plus contract? Is it a lump sum contract? Is it a cost plus with a guaranteed maximum price? Let's talk a little bit about maybe the nature of those and how those differ.
Sure. Well, let's talk about cost plus as a starting point. That simply is an agreement that the owner, they're agreeing to pay what the general contractor incurs to construct the project, plus some form of overhead and profit. And that oftentimes involves a certain level of trust that the contractor is going to make good business decisions about the subcontractors hired, the material suppliers selected, because if not, then the contractor could easily start to generate costs that are passed on to the owner that cause the project to be quite expensive.
Yeah. By contrast, if in a lump sum contract, the contractor is putting in everything that they think might be required for that scope of work, whereas on the cost plus contract, it's whatever the owner wants, and then it requires some really good documentation by the contractor to make sure that they can prove all those costs. It reduces some of the risk on the contractor. It almost eliminates the need for change orders. It's just whatever the scope is, and we'll just start doing the work. That can be helpful. Talk a little bit about how that differs from a lump sum contract.
Yes, well, a lump sum contract, you're agreeing on the front end as the contractor to perform all the construction required by the plans, specifications, and other details that have been made part of the contract. There may be situations that occur that cause the work to cost more, and the owner is not bearing that risk. The contractor is bearing that risk and has to be very careful to make sure they get solid bids from the subcontractors, because if they get a year into the project and price escalation occurs, or they don't have a contract locked in with a key subcontractor, then they can end up losing money on the job.
Frequently, when we're representing contractors, we want to make sure that contract says that the scope of work is everything that is shown on the plans and identified in this contract. If we're on the other side of this negotiation and we're representing the owner, we wanted to say that it's everything that can be reasonably implied from those plans, because the plans may not have everything. That's where the language of your contract, especially on a lump sum contract, can be critical as to whether or not it is only those things that are specifically shown in the plans, or it's everything reasonably implied from what's shown in those plans. And so you'll want to have that buttoned up when you're doing your negotiations. So we've talked about cost plus and lump sum. There's a little bit of a hybrid of that, and that's a cost plus with a guaranteed maximum price. And so that's where you can have those risks on both sides. You have the cost plus aspect of it, but what's really important at that point when you have a guaranteed maximum price is that you know exactly what the scope is for the cost plus with a guaranteed maximum price. When you put your pricing in and say, this is going to be our GMP, you better make sure that you've got everything in that. And I litigated a case a couple of years ago on behalf of a contractor who was new at this and putting together a cost plus with a guaranteed maximum price. And what he did was he got his prices from all of his subcontractors, he put his markup on it, and he put it all together and said, that's the guaranteed maximum price. That's not what you want for the guaranteed maximum price. You need to put some buffers in there, knowing that prices are going to escalate and that sort of thing. And so that was one where we actually had to go to trial for a week in that matter. It was very expensive for the client, but ultimately we were successful. However, it's one of those where I think had the contractor had the opportunity to reprice his guaranteed maximum price in that contract, he would have approached it a little differently.
Right. And obviously, a cost plus with a guaranteed maximum price is very attractive to an owner, especially an owner who has a very specific financing arrangement that they don't want to exceed. And in fact, a guaranteed maximum price as a component of the project may be required by certain financial institutions or financing groups who are essentially funding this project. They may only be willing to provide that backing if there is a GMP in place.
Yeah. Another type of contract that's becoming more popular, it has become more popular in the last 10 to 20 years, is a construction management agreement, where there is a construction manager, and now they've divided that up into being a construction manager, or it could be a construction manager at risk, which generally serves in the same role as the general contractor, but there are some slightly different terms. Those are a little more advanced and a little more detailed and nuanced, and we'll get into that another time on one of our later podcast. But with regard to the contracts we've talked about, we've addressed specifically the scopes of work, what's in the scope and what's not in the scope, and that's critically important. And that's one of the main reasons you want to have your contract in writing.
If we can do anything to help you with your contract, reviewing your contract, making sure you've got great terms and good coverage, give us a call, contact us, and we'll be happy to work with you. Thank you.